Welcome to all of you for this new video on the settlement of international disputes through arbitration. Today this is our great pleasure and privilege to be with the Deputy Secretary General and Principal Legal Counsel of the Permanent Court of Arbitration, Mr. Brooks Daly, who will share with us his in-depth knowledge and great experience in the field of arbitration. More specifically, we will discuss together the role of the Permanent Court of Arbitration and the role of arbitration to settle investor-state disputes and interstate disputes. We will focus especially on the advantages of arbitration to settle those disputes and also on the challenges that arbitration is facing in the settlement of those interstate and investor-state disputes. Mr. Daly, thank you very much for being with us today.
My pleasure.
What do you think of the role of the Permanent Court of Arbitration in the settlement of international disputes, and more specifically in the field of arbitration?
The PCA has a special role in the area of international disputes, being the first permanent intergovernmental body founded to assist states in resolving disputes through peaceful means, such as arbitration, conciliation, mediation, and fact-finding. This remains its role today. What has evolved a bit over the decades, 115 years of existence, has been the access to the court of disputes between states and private parties. So while the original mandate or role to resolve disputes between two states continues, today the majority of the cases dealt with at the PCA involve a state or state-controlled entity on one side and a private party on the other. What do we do with regard to these disputes? We seek to give the parties a neutral, efficient, cost-effective procedure that will allow them to resolve their disputes in a way that saves them both time, money, effort, and it's a growing area.
What are the recent initiatives and the current activities of the Permanent Court of Arbitration in the field of arbitration?
Well, for most of its existence, the PCA only had an office here in The Hague at the Peace Palace, which was constructed for the PCA, and had a staff that was exclusively Dutch. One of the things we've tried to do to better serve our member states, we now have 117 member states, is to be more present around the world. So this involves holding hearings, meetings, anywhere in the world where the parties may request. We have our first office, permanent staffed office outside of the Netherlands in Mauritius. And I think within the next year we will have a further office in Singapore. And so these relate to the need of the institution to facilitate dispute resolution for its users around the world. And part of that means being present in more regions and not just doing everything from the Netherlands. Another initiative has been to diversify the staff until the 1990s. So for almost 100 years, the entire staff of the PCA was Dutch. Now, with almost 50 staff members, we have nearly 30 different nationalities, which means that we can respond to disputes around the world in a language and in a legal culture that we have on the staff, and we can understand better what's going on in disputes around the world. Other initiatives have been trying to develop the most modern rules of procedure, some targeted at a specific sector, such as environmental disputes, and some general, our 2012 rules that seek to provide the most modern and flexible rules that we've ever had for any type of dispute that may come to the PCA.
So, for instance, what type of new rules?
What is new at the PCA when you're 115 years old, it's a bit relative, but in the early 2000s we drafted and our member states adopted a set of rules that are for disputes relating to natural resources and the environment. The member states considered that this was an area of particular public interest and that the PCA as a public institution should focus its services in this area where not enough attention had been paid so far. These rules take into account the potential need for speed in an environmental dispute where environmental damage may be permanent if not stopped quickly. We've also assembled lists of experts, both scientific and legal experts, that can be appointed in these cases, making it easier for parties to these disputes to find competent arbitrators to judge their cases and scientific experts to give expert evidence. So that's one example. Another area that we're looking at now, it's very early, but is the potential for using more arbitration and resolution of disputes between corporations and individuals who say their human rights have been violated in the course of an international investment. But those are the early days there.
Yeah, this is really new and revolutionary indeed in the field of international law. So now I would have a question regarding interstate disputes. So what are the advantages of arbitration to settle investor-state disputes? And what are the challenges that the settlement of investor-state dispute through arbitration is facing?
Well, this question of the advantages of interstate arbitration has posed itself for me because in the last few years we've seen a big upswing in interstate arbitration, at least compared to the last 50 or 60 years. And looking at the last about 40 interstate arbitrations, what I found was that speed, the ability to impose time limits on your arbitral tribunal, is one of the advantages that convinced parties to use arbitrations in specific cases in disputes where time was of the essence. There was a danger of, for example, of renewed armed conflict, and a long legal proceeding might have increased the chances that the parties would revert to arms. Having a very short schedule for an arbitration and a binding decision was attractive to parties in those cases. And that's something in arbitration. You can impose the time limits on your arbitrators. Before you appoint them to the tribunal, you tell them what your needs are, and in these cases it was, we needed an award from this tribunal within a year, for example, and the arbitrators won't accept the appointment unless they can do that. You can imagine you can't do that in a national court in your own country. If you show up there and say, I want my case to go before everyone else, it's unlikely to be the case. So that's one thing that interstate arbitration can do that has attracted parties to it. The other aspect I found that seemed to attract people was, well, I looked at the Law of the Sea Convention because that is the biggest producer of interstate arbitrations in the last 20 years. And that convention, which governs the seas, most of the world is covered by oceans and seas. It's often called a constitution for the seas. It refers to arbitration as the default mechanism for interstate disputes. I wondered why, and I looked at the negotiating history of the convention. And it's very clear, in fact, that the French delegation argued very strenuously for arbitration to be the default mechanism under the treaty. And they described their preference in the following way, saying that they considered arbitration to require the lowest sacrifice of sovereignty of a state, as opposed to other binding dispute resolution mechanisms. And it was tied to the fact that the states, parties to the dispute, got to pick the arbitrators. They constructed their own tribunal. And that, in a way, they were more closely related, had a stronger relation and bond with the tribunal, and that was a smaller sacrifice of their sovereignty than, for example, submitting a dispute to people that they had no or very little effect on, the constitution of the body that was deciding. So those are what I found in my study, where the seemed to be at least the motivations that the parties who chose these sorts of this mechanism expressed themselves.
And with respect to the challenges that the settlement of interstate disputes through arbitration is facing?
Yes, the challenge to interstate arbitration, I'd say, is the same challenge that confronts any binding third-party dispute resolution mechanism for states. That is, states are sovereign, and in principle they can't be judged by other states. So when they agree to submit to the binding legal proceeding, they're very careful about it. and they don't do it easily. And states essentially have to be convinced that they're better off losing a dispute than allowing the dispute to go on and continue to interfere with their relations with another state. But once you give the power to decide a dispute in a final and binding way, whether it's to an arbitrator or a judge, they have the same power to finally decide the dispute, you lose power over it. And a state otherwise is sovereign, and they don't have to agree to anything if they're simply in negotiation. So many states prefer to leave these disputes at the level of negotiation, and that may mean that they'll go on for a very long time. But that is the main challenge to going to arbitration or court adjudication of an interstate dispute, and that is that states are very careful about when they consent to have another body decide their dispute in a final and binding way.
And now moving to another type of dispute that is gaining an increasing importance at the Permanent Court of Arbitration, I mean investor-state disputes. What are the advantages of arbitration to settle investor-state disputes? And what are the challenges that the settlement of investor-state dispute through arbitration is facing?
Well, first I should say that among our member states, there are some states that have no investment treaties and don't offer this sort of protection to foreign investors. And we have other member states that have many investment treaties in force. So the PCA, as an intergovernmental organization, doesn't have a particular policy as to whether its member states should or should not accept arbitral jurisdiction to decide disputes with foreign investors. However, once they do decide to do that, we're there to help them have as efficient a procedure as possible. But just to clarify that the PCA doesn't have a policy position. It's not our role to have a policy position on whether our member states should have investor-state arbitration options or not. But when they do, well, the common advantages cited are one is the same as we see in any kind of arbitration. It's really neutrality. A foreign investor doesn't like to go before a court, a judge of the country where he or she has made an investment. They don't think that the local court in the country where they have the dispute is going to be neutral and view them in a fair, neutral way. So they prefer arbitration because they won't be judged by the courts of the same country where they have a dispute. So neutrality is the obvious aspect of arbitration that's attractive to investors. For states, the traditional explanation is that this avoids politicizing disputes where states would otherwise might be called upon to defend their own national. Before these treaties, the traditional way for a state to protect its investor was investor says to its government, something bad happened to me in this other country where I made an investment. Protect me, do something for me. And so that government then contacts the host state of the investment and complains. And this leads to perhaps a complication of the diplomatic relations between the two states, this diplomatic protection of one country of its own investors vis-a-vis another state. Now, investment treaties allow investors to bring claims directly against the host state, and they don't have to call upon their own government to get involved. So a potential advantage is avoiding politicizing what are mainly really commercial investment disputes and leaving them off of the political, diplomatic level of two states and keeping them between the investor and the host state. Now, what are the challenges for this area of dispute resolution that I see? I mainly see the challenge being that many of these treaties, first early generation investment treaties, are drafted in a very broad, vague way. And they're open to interpretation, and some states that have signed them have been surprised by the interpretations that have come from arbitral tribunals called upon to interpret these treaties. Now, the obvious answer is redraft the treaties, renegotiate the treaties, and that is going on, but we already have a network of around 3,000 of these treaties in place, and it takes a long time. It's a cumbersome process for states to renegotiate treaties. So I think that the big challenge is making these treaties reflect the intentions of the states clearly, and that's going to be a process over a number of years. And in the meantime, there could be more decisions that come as something of a surprise to the states as to the interpretation of the treaties, but that's going to further influence the way they think these treaties should be drafted. And we've seen an evolution in the way these treaties are drafted, some much more clearly now describing what the states intended. But that will be an ongoing challenge for a number of years, I expect.
And to conclude this interview, how do you see the future of the settlement of international disputes through arbitration? And in this context, how do you see the role of the Permanent Court of Arbitration in the future?
Well, assuming that economic integration of the globe continues, then the continued growth and demand for arbitration services should be expected. It's when we have international connections, international relations, whether it's commerce or political, that's when arbitration is called upon, because nobody wants to go to someone else's own court. They want a neutral tribunal. And the more that we have international interaction, the more we'll need arbitration. The present trend is towards greater and greater interaction, more economic integration, more trade across borders, and cross-border interaction means more arbitration. So that's my expectation, is assuming that, the current trend goes on into coming decades in terms of economic development, that we can expect increasing demands on international arbitration and the PCA.
So the future looks very promising.
I think so, yes.
Mr. Daly, thank you very much for sharing with us today your in-depth knowledge of arbitration and your broad experience in this field. Thank you very much to all of you for watching, and goodbye.